afternoon, everyone. Thank you all for coming. It gives me great pleasure to introduce to all of you Dr. Sharif Elgebeily, who joined the CCPL as an assistant research officer in March 2015. He has since also taken on part-time lecturing here on a Common Core course on the rule of law, and he's also instructing on the clinical legal education refugee stream under the center. Prior to moving to Hong Kong, Sharif served as editor-in-chief of the peer-reviewed Westminster Law Review and was visiting lecturer at the University of Westminster. He has an MA in International Human Rights Law from the American University in Cairo, and previously he's worked on space policy for the European Commission in Brussels, with the Iraq team of the UN Department of Political Affairs in New York, and with the Child Law Center in Pretoria. His research interests include comparative constitutional law, the work of the UN Security Council in maintaining international peace, international criminal law, the rule of law, and international human rights law. In April, he defended his doctoral thesis and was awarded his doctorate from the University of Westminster on the subject of the rule of law at the UN Security Council. And we're very, very pleased to have him here today to present part of his thesis with us. He proposes to discuss the application of the rule of law framework to the UN Security Council. Thank you, Sharif.
Thank you. So thank you very much for the wonderful introduction. As Pooja's mentioned, this is heavily based on my doctoral research, so it's been quite an effort trying to condense 300 odd pages and 4 years of research into a 40-minute presentation, but I'm going to give it my best shot. So I started researching this in 2010, and then around halfway through, actually, everything seemed to go my way, really. It kind of changed overnight. In 2012, the UN General Assembly adopted a landmark declaration that the rule of law applies to all states equally and to international organizations, including the United Nations and its principal organs, so including the Security Council, and that respect for and promotion of the rule of law and justice should guide all of their activities and accord predictability and legitimacy to their actions. So initially I had two research questions when I first set out that I wanted to answer. The first of these is, what should the rule of law look like at the Security Council level? Because I think everyone here will be familiar with the rule of law at the domestic level, maybe even to a certain extent at the international level, but what I'm trying to present is a bespoke framework of the rule of law that would be applicable directly to the UN Security Council. And the second question is to identify whether the Security Council responses under Chapter 7 of the Charter to actual or potential threats to the peace have incorporated the elements that I identify in question 1 in the research question. And I've taken as my temporal scope 1990s onwards, which is essentially post-conflict, post-Cold War, sorry. The reason why I've chosen post-1991, I think generally scholars seem to agree that there's this seismic shift from before 1994, the fall of the USSR, and after 1990 on the UN Security Council. And there's really, in the decisions that have been taken, the resolutions that have passed, the number of times that the veto has been used, there's a huge difference between Security Council behavior before 1990 and Security Council behavior after 1990. So I'm really interested in how the Security Council works after 1990. I think also because it will help inform how the Security Council works today. It's no use really looking at how it worked in 1960, because I don't think that that's going to be beneficial for looking forward to a rule of law framework. So even though the Security Council has been identified by the General Assembly Declaration to need to adhere to the rule of law, as we all know, those resolutions are not legally binding. So I think it's important to identify for four core reasons why the rule of law should apply to the UN Security Council. And the first of these is the limited composition of the Security Council. Now there are 15 members today. There were originally 11. But it's tasked with acting on behalf of all of the members of the United Nations, and that is essentially 193 states. Each of those have their own governments, their own political agendas, and their own interests. And frequently these interests are aligned, but the Security Council is not created to forward the interests only of the P5 members, the permanent 5 members who are perpetually on the Security Council, but as a maintainer of international peace and security, that is to say, all of it, all of the UN members' peace and security, and not selected elements. And so the first reason why I think the rule of law is important is because of the limited composition of the Security Council. It's important to have a framework in place to ensure that peace and security as a general theme is maintained, and not just the peace and security of the national interests of the 5 permanent members. The second reason is the decision-making process and the use of the veto, which is a very troubled issue. Decisions under the UN Charter should be made by an affirmative vote of 9 members, including the concurrent votes of the permanent members. So this is the clause, obviously, where the veto is, finds its roots, and therefore no Chapter 7 resolution emerges from the Security Council without at least the acquiescence of the P5. And it's not difficult to imagine, given this power, there are obviously self-servient or national interests, political agendas that come into play, which is an issue that was raised as far back as 1945 at San Francisco, where the UN Charter drafters essentially came up with the text of the UN Charter. It was raised by Ecuador and Venezuela, who were concerned that the Charter contains such a broad delegation of the powers of the UN to the Security Council that it appears practically inacceptable. And so, stretching beyond the previous point about the representative nature of the Council, this point takes into consideration the inherent bias that's attributed to the veto, and questions how do we ensure that the decisions of the P5 are made without an improperly biased agenda. The third reason why I think it's important is the extended competence of the Council. And of course, peace and security is a very all-encompassing theme today. It incorporates the AIDS epidemic, it incorporates women in conflict, it incorporates climate change. It's become an expansive term, whereas arguably, initially, peace and security related specifically and exclusively to international armed conflict. That was the extent to which peace and security was defined back in when the drafters were originally coming up with the Charter in 1945. And so whilst all of these issues are relevant in their own right, there needs to be some sort of reining in of Security Council measures to ensure that it's not just a carte blanche for the Security Council to intervene where and where it sees fit, and to essentially encroach on the jurisdictions of others, of other organs within the UN, or of the sovereign states themselves. And the final reason is the legally binding nature of Council resolutions. Now, there's a great deal of discussion about whether non-Chapter 7 resolutions are legally binding on states or not, and I'm not going to enter into that discussion today because I think it's just far too lengthy. But suffice to say that there is a point at which Security Council resolutions become legally binding. And as a result of that, the fact that the Security Council can place these obligations on states and in some cases non-state actors and individuals through the resolutions that the states have to put into force, there needs to be a structure in place to ensure that, again, these are not done arbitrarily. So, we've discussed, so we've discussed why, and now we're going to essentially discuss what is the rule of law. And there's been a great deal of discussion about the rule of law. Bingham has a seminal book called The Rule of Law, in which he identifies numerous components of the rule of law. And there are various legal organizations, the IBA, domestic jurisdictions, constitutions, all enter into discussions. But I think that for the purposes of today's presentation and my own research, the definition given by former Secretary General of the UN, Kofi Annan, in 2004, which was echoed by the current Secretary General, Ban Ki-moon, defines the rule of law as a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable. The laws must be publicly promulgated, they must be equally enforced, independently adjudicated, consistent with international human rights norms, there must be measures to ensure adherence to supremacy of the law, equality before the law, accountability to the law, fairness, separation of powers, participation in the decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. Now, of this, it's a very complex paragraph there, I think. So out of that, I've derived 8 components for the rule of law for the UN Security Council. The first of these deals with transparency and public promulgation, which I've deemed here clarity of action. The second is legal certainty, equality before the law, and what I call the predictability paradox, which is essentially the avoidance of arbitrariness and the supremacy of the law, as well as the fairness in the application of the law. There's also consistency with international human rights norms, and the separation of powers, the equitable participation in the decision-making processes, and accountability to the law. So clarity of action, as I mentioned, deals primarily with transparency and public promulgation. Of course, there are no laws that are publicly promulgated by the Security Council, but the equivalent would be the resolutions. And so we need to ensure that the Security Council's decision-making process is both clear and transparent, and publicly available to other member states and non-council member states and the general public. Now, of course, I'm able to do this research, and so that in itself is an indicator that the information is available. It's available on the website, it's available through statements, through verbatim records, and through the resolutions themselves. So the information is there. To a certain extent, there are 6 UN languages that it's translated into. So you have Russian, English, Spanish, French, Arabic, and Chinese. But the problem that I have with the clarity of action at the Security Council is that despite the fact that the general norm should be for public meetings to take place, where you do have access to information, increasingly there is recourse to private, closed-door meetings. And this has increased rapidly since 1999. Prior to this, they were specifically used for mandated reasons, such as the reappointment of the Secretary General in 1996. In 1994, we see 4 closed meetings. And then in 2000, this leaps drastically to 2000. Since 2000, there have been over 400 closed-door meetings. And at one point, over 20% of the council meetings were conducted in private. Now, that is very worrying. In 2002, that was 272 council meetings were conducted in private, which is 20.22%, for those of you who are interested in the statistics. And this doesn't seem to be relenting to this day. So we have, since 2010, 98 closed-door meetings, which is an average of about 20 a year. Year on year, there's also been an increase in the resort to closed-door meetings. In 2012, there were 15. In 2013, there were 20, and in 2014, there were 22. So this is an upward trend rather than a downward trend, despite the fact that the Security Council has identified through its president that there needs to be increased transparency, and we do have the establishment of groups that are pushing for increased accountability and transparency. So even though in 2010 the Security Council reaffirmed its commitment to increase recourse to open meetings, particularly at the early stage of its consideration of a matter, this has not really been followed through with. And so there's this great citation by Michael Reisman, Professor Michael Reisman, who compares the Council to a parliamentary matryoshka doll. And he says that the Council now contains ever smaller mini-councils, each meeting behind closed door without keeping records, each taking decisions secretly. Before we have the larger council meeting of 15, you have the P5 who have met in consultation. And before these P5 meet, you have the P3. So you have the US, the UK and France. And they have met in consultation at one of their meetings in New York. And so after the 15 members of the council have consulted and reached their decisions, they adjourn to the council chamber where they go through the formal motions of voting and announcing their decision. And now, decisions that appear to go further than any time in the history of the United Nations are ultimately being taken, it seems, by a small group of states, separately meeting in secret. So this is extremely worrying for the component of transparency. With respect to legal certainty, the legal argument to council action needs to be clear. Resolutions should highlight which article of Chapter 7 any resolutions are being taken under and its parameters, as well as clearly stating the legal justification for taking such action, the nature of the threat that this resolution intends to address, and the nexus between the threat and the course of action pursued. So that is to say that the legal certainty component is the explanatory element of the resolution, showing what the Council has identified as a threat, why it has chosen to respond in this way, and what the extent of such response should be. This is a citation from the UN Charter itself. So the Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations and decide what measures are to be taken under Articles 41 and 42. This is Article 39 of the UN Charter. And this is what I like to call the gateway article, because essentially this is the gateway to 41 and 42. So without a determination of what the threat to the peace is, in my opinion, what I propose is that there should be no action under Article 41 and 42. So that's why I call it the gateway, because I think you need to enter through it. This determination, if we look historically, has been followed under many circumstances. So in the case of Angola, there have been numerous resolutions. All of those had a preceding Article 39 determination. Somalia, again, Chapter 7 resolutions have reiterated the threat under Article 39, and even resolutions that were not taken under Chapter 7 have made mention of the Article 39 determination. In Haiti, for example, all but Resolution 861 in 1993, which lifted the trade embargo, made reference to the Article 39 determination. And then in Afghanistan, we see something that's very interesting, what's termed the parallelism of competence. So if you use a chapter, if the Security Council uses a Chapter 7 resolution to set up a mandate or an authorization, then Chapter 7 must also be used to both extend, to extend and disband the mandate or the organization. So we see this in Afghanistan with reference to the International Security Assistance Force, the ISAF, which was the mandate for which was created under a Chapter 7 resolution. And then similarly, you had the United Nations Assistance Mission in Afghanistan, UNAMA, which did not have a military element in the same way as the ISAF, and so it didn't require a Chapter 7 resolution. Now, in the extension of both of those respectively, Chapter 7 has been used to renew the mandate of ISAF, and with the Article 39 determination, and Chapter 7 has not been used to renew the mandate of UNAMA. And so there's been no Article 39 determination necessary there. In Sudan, however, there is no parallelism of competence with the United Nations Interim Security Force for Abyei, UNIFSA. So the resulting extension, even though that was created under Chapter 7, should have been renewed under Chapter 7. So it wasn't, and so there's a difference there. There's no reference to Chapter 7. My argument is that there should be explicit reference to Chapter 7 in order to qualify for this legal clarity element. And in recent times, authorizing resolutions has often included three elements: the determination in accordance with Article 39, the statement that the United Nations Security Council is acting under Chapter 7, and an explicit decision to authorize member states to use force. So this is what happened regarding Iraq, not the second Iraq War, the first Iraq War, Bosnia, Somalia, Haiti, Rwanda, the DRC, Albania, and a whole host of countries. But it's not always been the case historically. And in fact, it wasn't really until the end of the Cold War that this was relied on. And yet, it's a clear legal basis for action by the Security Council, and it's necessary. It has been necessary in recent years to explicitly state that this is a Chapter 7 resolution to avoid any kind of hesitation or discrepancy in the interpretation. Nonetheless, there's been Chapter 7 terminology used in non-Chapter 7 resolutions that have come out of the Security Council. This is extremely confusing. Most recently in Syria in 2013 with Resolution 2218, there's a great deal of Chapter 7 terminology the Security Council decides, and all of these very forceful verbs that were used. Similarly, in 2006 with North Korea, although they weren't officially Chapter 7 resolutions, they were all but in name. So this runs contrary to the legal certainty element. And the clear legal basis essentially has to state what is the specific threat, which again doesn't always happen. And so on this particular element, I think that there's much to be done by the Security Council. Equality before the law essentially relates to how well or to what extent the Security Council reacts to analogous threats to the peace. If it doesn't react in the same way, then it would be unequal and, I argue, would contravene the principle of equality before the law. So the obvious reference or the obvious comparison is Syria and Libya. Now, before we even begin, I'd like to say Syria is not Libya and Libya is not Syria, of course. There are individual elements to each, and there are very specific idiosyncratic issues that are at play in both of these states. And yet, the intersection between the situations of both countries becomes relevant to this component of equality with the response of the Security Council. So in the case of Libya, it took less than a year between the first discussion of the situation at the Council in February 2011 and the declaration of the liberation of Libya by the new Transitional Council, including the passing of a Chapter 7 resolution, the authorization of NATO to militarily intervene in Operation Unified Protector, and the end of that particular military intervention on the 31st of October 2011. So it took less than a year. In contrast, in the same time period, the Security Council managed to pass one resolution on Syria. Since then, there's not been a single Chapter 7 resolution. There's been the threat of Chapter 7, despite the fact that there's clearly been the use of chemical weapons. There's a standing total, obviously, of, as we all know from the current refugee crisis, around or over 7 million refugees, and there have been hundreds of thousands of deaths. The situation in Libya was also afforded far more attention by the Security Council, so there have been fewer discussions on the subject of Syria. In 2011, Libya was tabled as an individual subject for discussion 23 times. Of the 4 Chapter 7 resolutions on Libya in 2011, it took 4 days only from the Undersecretary General's briefing to reach unanimous consensus for a Chapter 7 resolution imposing an arms embargo, a travel ban on key figures of the Gaddafi regime, and an asset freeze on the Gaddafi family, in addition to the referral of the situation in Libya to the ICC, to the prosecutor at the International Criminal Court, which previously with the Security Council, of course, has been a contentious issue. The situation in Syria, however, has been discussed around 20 times since the beginning of 2011, with only a handful of resolutions being passed, none of which, of course, have actually been Chapter 7 resolutions. We've only had the threat. With nuclear threats too, we see double standards on the part of the Security Council. Israel, for example, is known to have nuclear weapons, although it's never actually admitted it, but through key pieces of US intelligence and whistleblowers, it's a kind of a well-known secret. And yet they haven't signed the Nuclear Non-Proliferation Treaty. India and Pakistan, too, have admitted to having nuclear weapons. They know that they each have these, and they also haven't signed the NPT. And yet North Korea, which did sign the NPT to begin with, and then decided to leave the NPT under its right as a treaty, has been singled out. So it signed the NPT, withdrew, and pursued nuclear weapons capabilities. And the Security Council took an unprecedented step in essentially going beyond its scope within the UN Charter and issuing resolutions 1718 and 1874, which it reiterated most recently in 2013 with 2094, imposing the obligation of the DPRK to re-accede to the NPT, which is extremely troubling under international law. Many of us will know here that under treaty law, essentially, this is in clear contravention of the Vienna Convention on the Law of Treaties. So the UN Security Council seems to be placing itself above the sovereign power of states to decide which treaties it should and should not enter into. And the double standards that I've referred to, as I mentioned, India and Pakistan both have decided not to sign the NPT. So they're free to pursue their own weapons programs, despite the fact that they have made no bones about the fact that they have a clear animosity towards one another. And I think that it's highlighted the most by the fact that during the discussions on North Korea, in the midst of these resolutions, both of the states, both India and Pakistan, were unabashedly pursuing their own nuclear capabilities, whilst the UN Security Council was directed towards North Korea. And astonishingly, only 3 days after North Korea launched its missiles in July 2006 into the Sea of Japan, India undertook its first test of what it calls the Agni-3 intermediate range ballistic missiles, which have more than a 3,000 kilometer range and a payload weight of 1.5 tons. There was no council condemnation, and there wasn't even a mention of the launch at the council meeting of July the 15th, despite the direct references under Resolution 1540 directed towards the DPRK to the prohibition of weapons and their delivery. And so it seems that the Security Council treats states differently against what it purports to suggest are independent standards. The predictability paradox essentially states that states should be capable of reasonably anticipating the Council's response to any of its given actions or lack thereof. Now, I've called it a paradox because, in my opinion, it is a paradox, because we want the Security Council to treat states the same. But obviously, as a political organ, it has to treat states individually, because, as I mentioned before, Libya is not Syria and Syria is not Libya, and there are various idiosyncratic elements to those. So there needs to be an independent standard, but at the same time, how do we have that independent standard whilst still advocating for the Security Council to treat each state on its merits? The independent standard that I'm talking about here is essentially where states take a stance towards, for example, territorial integrity and sovereignty. So the Chinese delegation, as its consistent position, does not favour the Security Council's handling matters which are essentially internal affairs of a member state, nor does it approve of resorting lightly to such mandatory measures as sanctions by the Council. Now, both Russia and China have taken this view that no intervention should take place in Syria. They took a similar tack in Zimbabwe, against Zimbabwe in 2008. But of course, we all know what's happening in Ukraine, whilst Russia has essentially gone into Crimea on its own. It's blocked any action by the Security Council. It's made, it has no qualms whatsoever about blocking action in that respect. The Council chose to intervene in Bosnia and Herzegovina in 1991, then failed to intervene in Rwanda to essentially stop the genocide in 1994, acquiesced to a NATO intervention in Kosovo without authorization in 1999, legitimized the Iraqi invasion in 2003 by the MNFI forces after the fact, and then intervened in Libya in 2011, and then decided not to intervene in Syria. And so there's this meandering support for territorial integrity that seems to be clear. Yes, we'll intervene, no, we won't intervene, despite the fact that humanitarian grounds are quite clear, I think, in all of these examples. On civilian nuclear weaponry, again, there's a clear discrepancy here. Iran, for example, has been, and now an agreement has been reached, but Iran historically has been subject to various rounds of sanctions because it needed to clarify its nuclear programs. And only due to the suspicion, I mean, in the reality of matters, there was no violation of its safeguards agreements with the International Atomic Energy Agency, the IAEA. And yet, under under Resolution 1696, Chapter 7 resolution of the UN Security Council essentially said that it must make mandatory the suspension required by the IAEA. It fails to identify what threat to the international peace there is in contravention to what I've already discussed about Article 39, and calls upon Iran without delay to take the steps required by the IAEA. demanding that it suspends all enrichment-related and reprocessing activities without any legal basis or legal clarity. Contrarily, Japan, which as of 2013 has held over 9 tons of unirradiated separated plutonium on its soil, and a further 35 tons in France and in the UK, in addition to having gone live with a reprocessing facility in late 2014, has had no repercussions, has seen no repercussions from the Security Council. It's estimated that it has enough material to construct 5,000 nuclear bombs through its weapons-grade plutonium, which is increasingly worrying because its civilian program relies entirely on a different source of nuclear power, which is enriched uranium. So there's a clear discrepancy with respect to this predictability paradox. I mean, states are treated differently, even though there is a unified approach that is purportedly taken by the Security Council. Consistency with international human rights norms perhaps is not immediately something that we would associate with the UN Security Council. Now, human rights for the Security Council, I think, is a two-pronged issue. First of all, it can be a catalyst for the Security Council to mobilize its decision-making and to essentially mandate a sort of intervention, military sanctions, that there will be consequences to any violations of human rights. But what I'm more interested in here is how and to what extent the Security Council sees that human rights bind or should govern its own decision-making process. And I see there are two elements here: sanctions and military intervention, Article 41 and 42. And under sanctions, I think that this has been informed by the situation in Iraq. Blanket sanctions in the early 1990s led to severe deterioration in the situation for civilians. And so as a result, we've seen some sort of learning of a lesson here. So we have increasingly targeted sanctions now. Timber embargoes in Liberia, diamond embargoes in Angola, financial sanctions and flight bans against individuals that belong to the Al-Qaeda and Taliban groups. And yet concerns remain about due process, because it's still very difficult. Once you are listed on one of these sanctions lists, it's very, very difficult to actually get off. It's something that has been lamented by the Office of the Ombudsperson, which was created to essentially deal with these delisting processes. And only 44 individuals have been removed in the first 5-year term. For military intervention, I would argue that the Council needs to take a more hands-on role to the outcome of the mandates that it gives to states or to groups like NATO, regional mechanisms. And this was actually one of the reasons for the reluctance of China and Russia to intervene in Syria, is because the situation in Libya was so lax for NATO. There were no repercussions, there was no legal redress for those who were affected, civilians who essentially said NATO has bombed our villages. The collateral damage was really quite serious, and there was no legal redress or no legal recourse for these individuals. So the Security Council issues these mandates, and it has a responsibility to ensure the appropriate implementation of its resolutions, which until now it hasn't really fully been able to do. The sixth component of the rule of law, I'm very conscious of the time, so I think I'm going to go quite significantly over, is the separation of powers. And in this, I would argue that the General Assembly and the ICJ and the Security Council each have their own mandates under the UN Charter. The UN is also built on this principle of the sovereignty of states, and so my question here is, does the UNSC encroach on any of these? And at the domestic level, maybe we are familiar with the rule of the separation of powers as being the difference between judiciary, the executive and the legislature. And the GA, the ICJ and the Security Council are not exactly the same, but there are seriously different mandates, some severely different mandates between the different organs. So the ICJ, as the principal judicial organ of the United Nations, has the jurisdiction over both advisory opinions and contentious cases. And it's been referred to in various cases that have been before the ICJ, Nicaragua, hostages, and so forth. So the difficulty I see with what the Security Council is doing now is that it's advancing international law by proxy, and it has no right to do so because it is essentially a political organ. And so it's established the International Criminal Tribunals, which has been argued and discussed by various authors. And I'm not stating that the ICTY or the ICTR are illegal, but in creating the statutes for the ICTY and the ICTR, there were new elements of international law that were introduced, such as the individual criminal responsibility, such as joint criminal enterprise, other elements of international law that essentially were not part of codified law before this, but that the Council really advocated. It's also started setting norms. So the Nuclear Proliferation Treaty I've already discussed under Resolution 1540, but with international terrorism too, it's come out with 3 resolutions that essentially have no temporal limitation, and they are generally applicable. There's no agreed definition, for example, of terrorism, or at least there wasn't when Resolution 1373 came out in 2001. And it binds states to a general rule of international law without this temporal limitation, which I argue is an overextension of the powers, whether you want to argue that that's ultra vires or you want to argue that that's a violation of this particular component of the rule of law. Thank you. Something that I suppose is down to personal preference. The penultimate component of the rule of law, I think, for me is the most interesting, and that's perhaps why I've left it till last, is because this deals with the veto, but I'll get to that in a moment. So with respect to the composition of the Council, the only time that we've had an expansion on the UN Security Council was in 1963, when it expanded from 11 to 15 seats. Now at the same time, it expanded the now 10 non-permanent members to 15. The now 10 non-permanent members granted 5 seats to the African and Asian states, 1 to the Eastern European, 2 to Latin American states, and 2 from Western Europe and other states. Now this was a decision that was taken as a result of the swelling of new members of the UN after decolonization and declarations of independence. So half of the UN membership now, well, at the time, consisted of recently decolonized African and Asian states. And so the decision was taken that the UN Security Council needed to reflect this increased membership. And since then, membership of the UN has expanded by a further 80 states, most recently in 2011 with South Sudan. And in fact, in the decade from 1990 to 2000, there were 30 states that alone that declared independence or sought to be recognized. But the current assignment of the Security Council hasn't really changed since then. And so essentially now you have 5 seats to be divided between an African group of 54 states and an Asia-Pacific group of 55, totaling 109 states. So that's over 56% of the total UN membership, which is given only a third of the seats on the UN Security Council. The Latin American and Caribbean group has no permanent seats, although it's 32 states. The Western European and other group consists of 29 states and is assigned 3 permanent seats. So there's a great discrepancy between the proportional representation of these groups on the Security Council. Now this has 3 major major problems I see. The first is that the goal of states from underrepresented groups like Asia Pacific or Africa to be chosen for a seat on the Security Council is less likely. As a result, the issues that they want to deal with or that they want to bring to the fore are less likely to be presented at the Security Council. And finally, of course, there's no permanent seat for an African state, which I think is a serious problem that the Security Council needs to overcome. Various proposals have been put forward, all of them have stagnated. Consultation of states as well has not always been something that the Security Council has done well. In some cases, states will have matters discussed that are very relevant to them, to which they're not even invited. And then, of course, participation in discussions. the votes take place first, and then we have the statements. And this is something that's been lamented, that it doesn't really matter what states say because the vote has already taken place. And finally, we have the use of the veto. Now, of course, the US, Russia, and China have been in the news recently, in recent years for the use of the veto. France and the UK actually have not used their veto since before 1990, so I haven't referred to them. The most vetoes at the Council is the Palestinian question from the US. But what's really interesting for me, I think, is that there's been an increasing Sino-Russian cooperation on the use of these double vetoes in recent years. And the situation in Syria has been the crux of this, with 4 draft resolutions double vetoed over the past 4 years. So what this amounts to is a serious lack of equitable participation on the Council. Which leads me to my final point, which is the accountability to the law. And essentially, the structure of the UN Security Council is that there is no body or organ that can oversee the decisions of the Security Council. So it has what's called competence. So what it says, it does, and there's no external oversight. There's no volition for the UN Security Council to seek the input of the ICJ, even though they can go to the ICJ to come up with, submit advisory opinions. And the ICJ is unwilling to try and interject itself into these political matters. We've seen this with Lockerbie, for example. The General Assembly can use Uniting for Peace, but it can't use this to monitor the decision-making process of the Security Council. It can only use it to circumvent it under certain circumstances where the Security Council fails to exercise its primary responsibility for the maintenance of international peace and security. So what does this essentially mean? What I'm suggesting is that the Security Council is far from adhering to the rule of law, even though it must do. On some issues, it does show improvement, for example, with the sanctions, but on others, there has been no change for decades, as we've seen with equitable participation and transparency. So what can be done? There's no political will to change, which is necessary. There's no sign that there will be any relinquishing of power through the veto or otherwise. And it's clear that the self-regulation that was at the heart of the UN Security Council when it was first set up is not working anymore. So the counterbalancing of these major powers in 1945, Russia, China, the UK, and the US, as well as France, is not working anymore. And so my suggestion is that there is a need for an external, independent, autonomous body to regulate the actions of the UN Security Council. I would argue that there needs to be a rule of law tribunal that the Security Council establishes under Article 29 of the UN Charter, under its powers to establish subsidiary organs. But of course, this takes us back to the first problem, that there must be political will to change. And so it's a kind of a vicious cycle. My ultimate conclusion is that the Security Council will not be able to self-regulate, and that there needs to be some sort of independent mechanism. Thanks. I apologize for overrunning.
Thank you very much, Sharif, for that very interesting exposition of the application of rule of law theory in the context of the UN Security Council. I don't think you overran at all. We have a lot of time for questions and answers, so we'll open up the floor to see. Yeah, please, if you have any questions for Sharif. Yes, Ben.
Yeah, so first of all, again, thank you for the good presentation. I have a question. The topics that are dealt with the Security Council, they're very political.
Yes.
At the end. And we have members there that it's quite impossible for them to ignore the political interests of their own countries.
Yes.
So do you think that one way to go about it could also be trying to make the Security Council less political, but not necessarily bringing members that represent different countries, rather than maybe having people come, let's say, from the UN, discuss a topic, bring a proposal that is transparent to vote at the UN as another mechanism to apply the rule of law, not necessarily having a group of people. I represent the US, I represent China,
right.
And then we naturally will discuss our own interests,
Yeah.
rather than try to depoliticize it totally by having some group of technocrats drafting ideas, looking at the different legal issues, and then bringing a proposal for a vote. That could be also a way.
It could be. The issue is that the Security Council was created to deal, I think, exclusively with political issues. And the very raison d'etre of the Security Council is to respond to threats or breaches of the international peace. So it has a very specific mandate. The problem that I see with the Security Council is that it's no longer doing what it set out to do. And not only that, but it's also starting to intervene in matters that are outside the scope of what is permitted by the UN Charter, which is really the overarching document. It's the constitution of the UN. So bringing in external actors already happens with the UN. So they do invite non-governmental organizations, they do invite representatives, they set up, they task missions, and the Secretary General, they will ask for his input, and they will ask him to set up fact-finding missions, or they will ask for help from other organs and other non-UN agencies. But whether or not they will listen to them, whether or not they will take this in a non-political way, I'm not entirely sure, because I think that it's very convenient for the permanent 5 members to have that power, and that's really the crux of the issue, why they're not willing to give up the veto, why they're not willing to expand the Security Council, why they're not willing to grant the veto to other member states, is because, when you have the power, what incentive do you have to give it on?
Very little.
Yeah.
Michael.
Given that, can you perhaps elaborate on exactly how this independent autonomous body would regulate the Security Council, how you see that would actually work?
It will take a great leap to get there, but I think at the moment it's a theoretical suggestion. But I would see it essentially as a judicial body, or as an international tribunal in the same vein as, say, the ICTY or the ICJ. It's a judicial organ, and essentially what I would propose is that it has 2 core focuses. The first is as a constitutional court, so to speak, for states to come forward and say, this decision by the Security Council violates the rule of law, and these are the reasons why. Now, of course, there would be no preliminary measures, or else you would just clog up the system. But there would be some sort of mechanism where states can say, this is not fair. The Security Council has voted for this, or it has voted against this. Or at least a group of states that can come forward together and put forward a measure. But it would also exist in perpetuity, in the sense that it would monitor the decisions of the Security Council, and it would help improve the procedures of the Security Council. So it would say, for example, it would suggest or recommend to the Security Council that more meetings need to take place publicly, rather than behind closed doors. That it needs to increase the participation of member states in the decision-making process by expansion. So it would drive that development, that evolution of the UN Security Council, which seems to have stagnated, because despite the fact that we've had numerous proposals put forward by African states, by the Secretary General, and by other groups, there has been no expansion of the Security Council. It's not proportionally representative at all. So that it would be an institution that essentially drives progress for the Security Council on all of the fronts of the rule of law. So a state might be able to come forward and say, for example, this resolution violates principles of international human rights law, or the international human rights norms. The sanctions regime doesn't provide sufficient avenues for due process, for example. Individuals are listed, and it's difficult for them to be delisted. The Office of the Ombudsman, despite being a great creation and a step forward, only has a recommendation, only is able to provide recommendations to the Security Council. The ultimate decision is the Security Council, or the committee that deals with that particular sanction. So there's no meaningful discussion with any of the members of the Security Council or the committees that the Security Council has created in order to progress this development, to make the Security Council procedure more transparent, more representative, more equitable, more equal for states. So it would take a great deal of political will just to kick it off. But once it's there, I think that it could do a great deal of good for the Council's legitimacy within the international community.
Yes.
The independent autonomous body you refer to for the UN in our nation has the equivalent of being the judges. So you have your separation of powers. So perhaps you're saying the UN should have a panel of judges to declare if a resolution is constitutional or not constitutional. So therefore the UN conforms to separation of powers and acts like a nation would in this context. So you haven't used the word judge. Is that too sensitive?
I don't think it's too sensitive. It's I think a choice of words. I would see it as being an international tribunal, and the judges, there would be judges who would have the same qualifications as judges that are nominated or elected for the ICJ or for the ICTY. They would need to have that background. They would need to be able to study the law, which in this case would be the UN Charter, and say that this is, for example, contrary to the purposes and principles of the UN, which overarch everything. They would be able to say that the Security Council, for example, must put temporal limitations on its resolutions and not take measures or make or pass resolutions that have, essentially no end. They're generally binding, and there's no limitation, there's no temporal limitation on it. So they would be able to assess it within that framework. It's something that I think, as I say, would be quite difficult to set up. Because in order to set up this legislative or this legal body, this judicial body, the Security Council would essentially have to relinquish that competence. But in the absence of any governing framework, either within the UN Charter or within the rules of procedure, which to this day remain provisional and have still not been fully adopted, there needs to be some sort of, particularly when these resolutions are legally binding on states, there needs to be some sort of judicial intervention in order to regulate the process.
Raymond?
Dr. Elgebeily, I come from a political science background, so excuse me if my analysis is not particularly related to the rule of law. What do you think is the function of the United Nations Security Council? Should it reflect the inequalities of power in this world and try to channel those inequalities towards a more neutral forum? Or do you think it should embody the ideals of equality between states meeting as sovereign equal partners in an international forum? And if the UN Security Council is to conform to a rule of law framework, does that run the risk of driving states into alternative forums that allows them to express their inequalities, or rather give weight to their inherent inequalities in power?
Okay, so I'll start with the role of the Security Council. And if I have misunderstood your question, please do correct me.
Thank you.
But I see the role of the Security Council as being very specific, and it's outlined very specifically in the UN Charter. So it has primary responsibility for the maintenance of international peace and security. That doesn't mean that it's the only body that can deal with international peace and security, but it has primary responsibility. I don't see it as an equal organ. It can't be by definition, because we have the P5 members, and so that in itself is an example of inequality. To give more power to 5 states than you do to 10 is unequal. Does that mean that it can't be representative? No, I disagree. I think it must be representative for the reasons that I think I've outlined. In terms of states going to alternative forums, I think that already is happening. What we see, for example, the resolution of the situation rather than resolution of the Council, the way in which the situation in Iran was resolved did not come through the Security Council. It didn't come as a result of sanctions, or at least partly because of sanctions, because Iran wants the sanctions lifted. But that, if it is such a threat to the international peace, was not resolved by the Security Council. It was resolved by political means. It was resolved by alternative forums, as you've already mentioned. So it's already losing its